you forgot your cue. I told you to ask me about my adventure this morning in putting on a suit and tie.
I thought that was off because you, sir, are not wearing a suit and tie anymore.
I know. So it wasn't for you. Which you know how
Well,
like people well, I don't want to mess my shirt up. I can reuse it now. You know how it's probably common knowledge now that ever since the Zoom era, uh, a lot of people were telecommuting, and so they would probably put on a shirt and tie, but they were
nothing
wearing
underneath.
shorts underneath,
Yeah.
right? Um, so I did something this morning, and I was thinking only a libertarian would do this. So I put on a suit and tie to take a photo of myself because I need a passport photo. But I don't need a
Okay.
regular passport photo. I need a photo that I can use for my Liberland passport because I'm going to Prague in December for the signing and announcement of the Liberland Constitution.
Hello and welcome to Haman Nature. I am Adam Haman, and that fine fellow fiddling with his pipe on a Houston morning is one Stephan Kinsella. How you doing, sir?
I'm in fine fettle.
You're a fine fiddle and a fine fellow. For those of you who just woke up underneath a rock, Stephan Kinsella is a legal theorist, one of our best, and also the author of this highly influential book here, Against Intellectual Property, and also recently the author of this fine book here, soon to become wildly influential, Legal Foundations of a Free Society. And you can also find his work on his blog, which is stephankinsella.com, where he writes about all sorts of awesome things. And most importantly, for those of you who don't know, he's just a great guy who just came and visited the wife and I in Vegas just a few weeks ago.
I did, and that was fun. It was a great trip, one of my best trips of my life.
He flew over the Grand Canyon in a helicopter. Not everyone can
Got to
say
see
they've
it.
done that.
And we landed inside the Grand Canyon. That was cool, and we survived, which was good. And it was Greg's birthday, Greg Moran's birthday, and that was good. We saw uh, Doug and Deanna French for dinner that night, and then we saw the lovely Adam and Jen for dinner at the Venetian in Venice. That was cool too. I know it's tacky, but the Venetian at St. Mark's Square in the Venetian in Vegas is just awesome. I know it's tacky and kitschy, but I loved it. Loved it.
Yep, I feel the same way. No shame. I want to talk to you about a bunch of stuff today, but first, I want to talk to you about this great thing you have created. I'm going to flash it here on the screen briefly just because it's so pretty. But you created something called the Universal Principles of Liberty,
That is correct.
and it is just a glorious thing. I want to talk to you in depth about it, but maybe you want to talk about why you would go to the trouble of doing such a thing and what you think it's for.
I will. That's a good, but you forgot your cue. I told you to ask me about my adventure this morning in putting on a suit and tie.
I thought that was off because you, sir, are not wearing a suit and tie anymore.
I know. So it wasn't for you. Which you know how
Well,
like people, well, I don't want to mess my shirt up. I can reuse it now. You know how it's probably common knowledge now that ever since the Zoom era, uh, a lot of people were telecommuting, and so they would probably put on a shirt and tie, but they were
nothing
wearing
underneath.
shorts underneath,
Yeah.
right? Um, so I did something this morning, and I was thinking only a libertarian would do this. So I put on a suit and tie to take a photo of myself because I need a passport photo. But I don't need a
Okay.
regular passport photo. I need a photo that I can use for my Liberland passport because I'm going to Prague in December for the signing and announcement of the Liberland Constitution, and I need to get a passport, of course, to do that. So I need a passport photo.
And so you did.
So I did. So I took a photo of myself, a selfie against the back wall, a white wall, and meeting passport standards because we have to pretend to be a government to get government status, you know. And that ties
You're
into what you're asking about.
are you trying to tell me that at this great officious occasion, delegates from all across the world aren't going to be in attendance celebrating the whatever of this new whatever?
Well, so we'll see. Actually, that's one thing I'm doing. I'm trying to get the principles of liberty, which you just flashed on your screen, somehow incorporated in the Liberland Constitution. So here's the deal. I have been. How long have you been a libertarian? About as long as me, right?
1990?
Okay. I'd say 1979 for me. But anyway, um, and over the years, you've probably seen this too. In the early days, we used to get these magazines to like Reason and newsletters, and there was all these ads for the latest libertarian project, right?
Yeah.
Floating Nations, Blue Seed, Project Atlantis. I mean, I lost track of them. There's so many. They're all pie in the sky, either scams or just vaporware. Although half of them are well intentioned, it's just the people desperate to have some semblance of liberty in this unfree world, right? I've always been curious at them, and there's still projects going on. In fact, the Free Cities Conference, which I just went to in Prague last week, was amazing. It was I don't know, several different projects all attempting to have enclaves of liberty one way or the other around the world, like Honduras,
Yeah.
which you and I went to Prospero in Honduras, um, which had a chance of making it if the government didn't threaten it, which we'll have to wait and see what happens.
I mean, it's not dead, and the other one,
No, no, it's not dead.
Morzon is doing just fine.
Yeah, there's others, and there's other things. There's this thing in Dubai where they have a kind of common law zone, and there's these. I think someone said at the conference that there's like 43 special economic zones in China. It's like, well, why don't you just make the whole country special economic zone? I don't get it.
43.
It's
Okay.
like that's the right number of um and I was enlisted to help with the Liberland project of 6 or 7 years ago and I kind of helped draft their first constitution. But the whole time I was kind of uneasy about it because I'm an anarchist, not a statist, and the constitution is really the document that helps set up a new government. That's what it means to constitute, to make, to create. Which is why I'm frustrated with when libertarians talk about the U.S. Constitution being one of these great founding documents of liberty, and the original U.S. government is meant to protect liberty. It's completely false. I mean, you could argue that the original 13 states or colonies were kind of proto-libertarian because they weren't minimal states exactly, but compared to today's states, they were pretty minimal. Like their main job was to enforce contracts, protect property rights, stop crime. I mean, it wasn't 100% libertarian, but a minimal common law state is pretty close to. It's closer to our ideal, I would say, than today's large states. Um, but if you had these 13 colonies or 13 states, what did the United States government add? And by the way, I don't know if most people realize this, but we call the U.S. government the federal government, but that's not its. There is no official name given in the entire Constitution. There's no name given to the government that it creates. Just
Hmm.
once or twice, it mentions the general government. Like it kind of presupposes there will be some kind of government, but it never says it. It's like it's afraid to admit it because it doesn't want people to realize the scam they're trying to pull off by creating something from nothing. Sort of like how Bitcoin was named Bitcoin, sort of almost as a slimy maneuver to make people think of this ledger entry on a spreadsheet as a coin by calling it a coin to bootstrap it into existence. It's a little bit shady, I think.
If you're saying that the naming rights are still up for grabs, I say Godzilla.
Yeah, yeah. Well, I was going to call Bitcoin decentralized permissionless ledger entries, but didn't have a catchy ring to it.
Not nearly as catchy. So
Um,
you went to create something way better than a constitution, a set of principles that, if adopted, could be the base layer, the foundation of a legal structure.
Correct. Yeah, and the reason I did it was because I've been thinking over the years of when I wrote my own theories based upon the work of Rothbard and Hoppe and other libertarians before me, clarifying theories. I've had to continually refine how I present the ideas and define terms And I think I finally have it to a point which is pretty concise. And in fact, about 3 or 4 years ago, well, when was the Reno takeover of the Libertarian Party? About 4 years ago,
22.
right? 3 years.
Yeah,
Yeah.
3.
At that, the Mises Caucus was taking it over, and they had enlisted me to help revise their statement of principles or their bylaws, whichever one it was. Um, and they wanted to try to get anti-IP stuff in there, but we didn't end up doing that. And I'm a little bit glad because it's a little bit particular. But as part of that, I did come up with a restatement of our property principles and our non-aggression principle, and that is in the Libertarian Party bylaws right now. I think it's plank 2.2.1 or 2.2, and I'm really proud of that because I think it is a really short, concise restatement of what libertarian rights are. So I've been having this idea for a while of having a sort of a not a codified, but like a concise, elegant, fairly uncontroversial general statement of libertarian principles. Not an argument for it, but just a statement of it that people can point to. So
Let's
that wouldn't work. Go ahead. Go ahead.
well, no, finish your thought.
I said that wouldn't work for Liberland because they wanted a constitution,
Yeah.
which was, and so I could inform it with libertarian principles, and their constitution is far more libertarian than the United States Constitution, for example, but it's still a constitution. So it
Well,
wouldn't work back then. But yeah, go ahead.
let's go through it a little bit just so people can understand what it is and what it isn't. If, for the love of God, you're finished unwrapping that hard candy or opening that tobacco pouch or whatever that rustling was for the past
I
minute
think
and a
it might have
half.
been my Ligter.
Your leader. All right. Well, what I really like about it, and we're going to get into the details, but it's a set of meta norms essentially that other private legal codes can be structured on top of. Um, so these codes that will come on top of the principles can expand, specific laws, but they can't, as long as they don't violate what they're signing on to. Like you could come up with rules for how late the swimming pool is allowed to be open or whatnot, but you couldn't do anything that would violate something foundational. I love that, and I want to read real briefly from the preamble, which says, in part, quote, "Their purpose is to foster conflict-free interaction. These maxims flow from reason, experience, and ethics. They are neither decreed by any state nor imposed by majority will," unquote. Great. Death to the state, death to democracy. These things come from something else, and you actually have to sign on the dotted line in order to be bound by them. I love that. I also love in the terms and conditions. I mean, like a good contract, it defines the terms it's going to use, and under person, parenthetical rights bearer, you say any sentient being whose inherent capacity for moral agency grounds a presumption of self ownership and reciprocal obligations, which is awesome. You left room for space aliens and AGI, but you've excluded cats and dogs and cattle. And um, I think I'm going to pause here for half a second and just kiss your ass a little bit. A lot of the prime movers in libertarianism are economists, which makes sense, and historians and philosophers. All of these make sense. All of us are political philosophers to some extent because that's what
Correct.
libertarianism is. But what we don't have nearly enough of are people who understand the law and legal
Yeah.
theory. And that's a
Yeah.
crying shame because, after all, what you have governing you is a set of laws once you abolish the state and
Yes.
construct and Capistan. And so this does that. This document is just beautiful. It's clear. It's concise. It doesn't use wishy-washy terms. It doesn't get
Yeah.
confused. So I think it's magnificent, man.
Thanks. In a sense, we're all legal philosophers, right? That's libertarianism is really a philosophy about what the law should be. So that's why some knowledge of law is essential. But the problem is, of course, lawyers are mostly statists, so they're not going to be of much help. And that's why the libertarians are better at this, although they're kind of sometimes sloppy and imprecise on on legal language. Like, for example, Rothbard and Evers, Williamson Evers, who's I think he's a historian, and Rothbard's a philosopher and an economist, came up with a breakthrough theory of contracts, which I think is unbelievably profound. But it's sloppy in some ways because they weren't lawyers, but it's better than what the lawyers came up with. By the way this project came about was there's a guy named Max, Free Max, um, who had been involved with Liberland as well, and he had spotted an opportunity for another kind of free country. It's called Bur to Will. It's a 400 square mile unclaimed res nullius in between Egypt and Sudan, and he wanted to try something like Liberland there, but not in a state, but with a statement of principles. So he came to me to do that. And so I started was the main drafter. Hans Hoppe looked at some drafts, and Max helped out with some of the language, and also three other lawyers who I know well. One is Alessandro Fusillo. He's an Italian lawyer who's brilliant, and these are all NCAPs and Austrians. And David Durr, a Swiss lawyer, and my friend Pat Tinsley, who is a lawyer in Boston. And but I was the main drafter of it with their sort of guidance and their input. And one thing about these principles is it's not only I try to be legally precise. I try to be stateless or not statist, and anarchist, and very precise in the terms, but also because of my not only my common law knowledge as an American lawyer, but because I went to school in Louisiana, which is the only civil law state, I am deeply influenced by the civil law and the Roman law, and so are Alessandro Fusillo, David Durr, Swiss lawyers, and Italian lawyers. And so this code, the style of it is inspired by the way civil codes are written, like the French Code and other codes, because unlike statutes in the common law and even the U.S. Constitution, which is more general than statutes, but still has an element of legal positivism and statutory law about it, like it states things as like we're decreeing what the law should be. You see, in the common law, laws made by judges, and they're seen as the primary finders and discoverers of what the law is, and it develops that way. So when the parliament or the Congress steps in and intrudes on that sphere, the judges are jealous of that, and they tend to be very stingy in interpreting, giving effect to statutes unless they're really clear. So that's why legal contracts and statutes in the common law world are very detailed, and they have like so many lengthy subparts, and they're just not elegant at all because they're trying to force the judge to budge from their adherence to the common law and to follow the statute. Whereas in the civil law, it's more legal positivist in the sense that people think of law as coming from the legislature, and therefore the judges are more ministerial. They're not like held up as high of a status as common law judges. Their job is just to interpret what the law is, which is seen as the civil codes. Now, that is legal positivist, but it's not completely terrible as it sounds, because the codes were really just elegant excuse me, elegant restatements of organically evolved Roman law principles, so which were developed by judges back in the Roman days. And so the civil law has an elegance and an economy of words which did inspire the way this is written, and I think that's why it reads so well. I mean, Max generated a poster version of this, which is what you showed, and he presented it at the Property Freedom Society conference with me and Alessandro and Hans Hoppe and David Durr this September, and it's just a one-page document which you can read. And as you say, it is not meant to be the details of law. It's meant to set the framework of the principles any legal system has to adhere to, which is why it does sort of borrow on the idea of Douglas Rasmussen and Denial, who are neo-Randian philosophers, and they view rights as what they call meta-norms, not norms directly. And that sort of harks back to Rothbard's idea that libertarianism is not an ethical theory, which really means that it doesn't tell you how to act in your daily life. It really tells us what laws are just, which means it tells us which laws we as society should respect and put into force. So the purpose of this document and the purpose of law and the purpose of rights is to guide us in a meta-normative way as to which laws are just and which laws we should respect and which laws should be enforced.
Yeah, my layman way of thinking of it is proper law delineates what you may not do, but it leaves this huge sphere of experience where you're just free to live your life as long as you don't violate these things you're just not allowed to do, like punch Stefan in the face and take his stuff.
That's
Um,
another good way to look at it. That way of looking at it is some people criticized my speeches I've given where I've said that the Roman law and the civil law of Europe, which embodies that, is as good as or better than the common law in some ways, because they said that, well, that's in the civil law, the rule is that you can only everything that's not permitted is forbidden. And that's not true. That is true of totalitarian systems like in the Soviet Union or Cuba or North Korea. It is not true of the civil law. Just because it has a legislated code doesn't mean that the rule is that all that is not permitted is forbidden. That's not true at all. The general rule is that you can do anything unless you violate others' rights, which is the libertarian rule that you're permitted to perform any action as long as you don't trespass upon other people's rights. And this also leads to the insight that libertarians speak about liberty and freedom, and they are good things, but our property rights really protect our use of a resource, but they don't. So, for example, you don't need to say, "I have a right to." So we'll say you have a right to freedom of speech. The reason we say that is because it's important to say that as a way to limit government power. If there was no government, you wouldn't need to say there's a right to freedom of speech. You would just simply say everyone has the right to perform any action whatsoever unless it violates the property rights of someone else. In other words, everything is permitted as long as it violates someone else's rights. So if I own a home, I can do anything in that home. I can have whatever sexual practices I want. I can have whatever religious practices I want. I can take a warm bath at night if I want. You don't have to have an enumerated list of rights. Like I have a right to take a warm bath on Wednesday nights. That's just a consequence of my right to private property of my home, which means that that freedom itself is just a consequence of having a property right. So if I have a property right in my body, then I have the right to think whatever I want, and I have the right to say whatever I want. So freedom of speech and freedom of thought and freedom of religion is just a consequence of that. So rights are instrumental because they are the way that you get freedom. But freedom itself is not properly said a right. Like there's no right to life. There's only a right to your body and to have no one interfere with it.
yeah, it's an unfortunate piece of sloppiness in our language that we say I have a right to rather than framing it in the reverse. In the principles, you define resources as physical only, which is sweet. Uh, IP is out. And even more importantly, you structure or frame laws and contracts as all rooted in property rather than anything else, which seems
Correct.
very, very clean to me.
And then that's that
Um,
Rothbard Evers title transfer theory of contract
right,
that informs
right.
that, by the way.
And then, as you just mentioned, much more fully, rights are defined exclusively as property rights, just to keep us from being confused. Um, I'm going to skip a couple sections because you brought up the fact that you own your body. Why do we insist in these principles on inalienability? In other words, why is Walter Block wrong about being able to sign a contract and sell
Right.
yourself into slavery or something? What is the fundamental? I mean, this is like a metaphysical distinction, but it also hinges
Correct.
on property rights. So, yeah, what are you getting at there?
Well, when we drafted the principles, we wanted to make it general and we wanted to avoid areas that are, say, not settled or not agreed upon yet by libertarians. But we took a stand on some things. We decided not to be too too wishy-washy. So for example, we took a stand on the state, so it's an anarchist document. Um, and also at the very end, we debated whether to put this in a secondary set of documents that some people might or might not agree with. That's the select unjust laws, and that's why I mentioned intellectual property in there. So there's a couple things in there that some libertarians probably don't agree with, and one is inalienability, that's voluntary slavery, and one is intellectual property. Everything else, I think most libertarians would agree on, or our principles or implications of our principles. We put the ones in there that maybe are slightly controversial because I think we wanted to take a stand on those issues. And on inalienability, that had to be mentioned because we had to mention contracts, what they are. Contracts are transfers of title to resources that are owned. And also because we had to have a clean definition of what rights are in general, and that is um, Article 2 and Article 3, self-ownership and original appropriation. So we distinguish them because there are differences between ownership of one's body and how you get ownership of your body, and ownership of formerly unowned resources, which you own by homesteading. If you didn't distinguish it, then you would have this sloppy thing, which some libertarians still say, which is, well, if you own something in the world that was unowned and you come to own it because you homestead it, which is Article 3, then by analogy you own your body because you homesteaded it, which then leads to the idea that you could sell it, because just like you could sell something or abandon something that you acquired, you could sell your body because you acquired that too. You homesteaded your body. And I think that's just wrong. So the basis for ownership of your body is your direct control of it. That is your best connection to it, your best argument for control of it. It's not because you homesteaded it. So there's a fundamental difference between who you are as a corporeal human actor with a body. I mean, you come into the world as a person and as a body owner, in effect. That is inextricably part of your personality and your identity. And so that is distinct from things that you acquire in the world that are unowned and they don't have a personality at all. Um, and so once you make that distinction, then you have to say, well, it makes sense that you could divest your ownership of a thing you acquire by selling it by contract. But for the body, because you didn't come to own it that way, um, aggression of your body is a different matter. Um, and that's why we have to mention that body rights are inalienable. It's because contracts are not seen as binding promises. They are seen as alienation of title to things that you own. And the art, and it's not in detail in here. By the way, I plan to write in the next month or so a detailed commentary on this thing, giving footnotes and further reading. But I wanted to do that in my capacity as just another person reading these principles and commenting on it, which is not binding and not authoritative. The principles stand alone and can be voluntarily signed onto by anyone willing to respect libertarian rights.
Oh, that's awesome. Yeah, again, my layman's understanding is just I can separate myself from my coffee mug and sell it to you, but I just cannot separate myself from my body. Like I could maybe sell it to you when I'm dead and not in it anymore. But yeah, there's no way I can't separate me from this thing and separate the two and give you one of them. It's not a
Correct.
thing.
Now, unlike some libertarians like George Smith and others who say that your rights to your body are inalienable, I don't think they're completely inalienable. There is a way to alienate rights to your body or forfeit those rights, and that is by committing an act of aggression. But that's
Yep.
the only way that someone has the right to use force, which is why we libertarians always talk about the sort of symmetry or the reciprocity aspect of rights, which is that or the use of force. So libertarians are not they're not pacifists, and we're not opposed to the use of force at all. We're just opposed to the initiated use of force, which means trespass, which means the use of someone's resource without their consent. But if someone is invading your property without your permission, um, then they have effectively consented to you using reasonable proportional force in self-defense. And so they've consented to you using their body to defend yourself, which means they have in effect alienated part of their control or their right to use their body because they have done something to you, not because they made a
I-
contract, but because they've done something to you.
I'm glad you brought that up. It was next on my list. You say in the principles that self ownership may be forfeited in whole or in part, just as you said, as a consequence of committing aggression, subject to principles of self defense and proportionality. There are libertarians, I know at least one, who reject this, as well as the principle of rectification as well. They say something like, the only thing you can do when somebody has harmed you is ostracize them or something, shun them. Um, do you have any idea where a legal theory like that might have come to, and maybe a
I
pithy
think I th
response?
yeah, I think that there are some libertarians that, they 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 ap they have this sort of, instinctive opposition to authority and
Right.
also to the state, which I understand the second one, but I think that because they're used to authority coming from the state,
Yeah.
they reject all authority. Just like we're used to in today's world, law being legislated law from a legislature, which is obviously, unjust and is actually not law. Okay, so you have this people say, "Well, then I'm gonna throw it all out. So I'm against all law and all authority." I think that's wrong. I think actually libertarians are in favor of order. We are in favor of justice. We are in favor of law and rights, and they don't have to come from the government. And in fact,
Right.
they can't come from the government. The government can only impair and impede and
Right.
distort and corrupt these things. And
It
so
can
I
give you
think that
the
may
bizarro universe of those things, but not the real thing.
correct. And so I think that may be part of what's driving it. Um, some libertarians say, "Well, you can't boss me around or push me around or tell me what to do." Oh, and they also have this kind of although they seem to reject the social contract, they seem to when they reject the contract, they have this idea because they've accepted implicitly legal positivism, the idea that laws have to come from a lawgiver, the state or the sovereign. They because they reject the social contract, and because they think of contracts as state law, then they think that they think that the only contract that would be valid would be one you sign up to, like, in writing. And so, therefore, they would say, "Well, an outlaw in an anarchist society, an outlaw hasn't consented to being punished, so you can't do anything to him." And I think that's just wrong. Just like you don't need the permission of an aggressor to defend against what he's doing, or in effect, you do have his permission. By his actions, he's granted you permission because he's treating your body as if he can use it without your permission.
Right.
He's treating your body as a means by the same logic, which is my rights theory, which I call estoppel. He's stopped from complaining about your use of reciprocal force against him. So he's effectively consented. So in an anarchist
Yeah.
society with private law, um, you don't have to get the permission of the criminal to punish him after the fact or to get rectification from him after the fact. Um, he doesn't have to have signed up to an insurance contract or a treaty or the covenant of that area. He basically he basically can't complain about law being applied against him. So
Right.
I think it is just to use force in a legal system against an outlaw.
I think that's precisely right. And again, I like to boil things down to a dumb guy understanding. And it's just this, as you say at the top in the preamble, these principles are a way to let us live amongst one another without conflict.
Correct.
And if you're not willing to buy into that, well, then we're just fighting now. So who
Correct.
in the world are you screaming to in protest when we're fighting? You decided you didn't want to play this game, and so now, yes, a force is going to be used against you. That's what fighting is.
Well, and who they're screaming to is the community. They are
Yeah.
when they object to being treated in a certain way, like to being punished or whatever, they are basically making an assertion. They're entering the normative realm. They're they're entering the realm of dialogue, and they're claiming rights. Now they're saying, before in their action they were denying everyone's rights because they were acting as an aggressor, but now they're claiming rights. And they're by doing that, they're granting the validity of the kind of basic values and norms that inform our libertarian, principles. So they're trying to have it both ways. They're trying to say, "Well,
Right.
now I'm saying that we all have rights, so you can't invade my body." But when they do that, they're implicitly admitting that that we have the right to self defense and to respond by force against someone who violated that covenant in the first place.
Yep. I think that's exactly right. Another thing that impressed me in the principles is you actually managed to handle things like weapons of mass destruction, nuclear warheads, uh, jars filled with plague sitting on a precarious shelf. And I just like the way you framed it. These massively lethal things that could not possibly be aimed only at aggressors and excluding innocents are things that anybody else around is going to have a justifiable interest in making sure these things aren't around or are contained or something. And I was
That's
just
Article 8. Yeah, that's Article 8, devices of mass destruction, and I give credit to Max. So Max wanted to put that one in there. Um, just like in the libertarian constitution, they're trying to appear like a state so they can get recognition from other states. So they had to put the trappings of sovereignty, population, um, statehood. They had to put that in the constitution to do what they wanted. Max was thinking, well, we want to have a statement of principles um, that will have some appeal to people. So he wanted to put the device of mass destruction in there, but we all worked out together to make it worded in a general way that I think is hard to object to by any libertarian. It's a little bit out of place because it's particular, but I don't think it's wrong.
right,
So so I worded it like, for example, if you were to use a nuclear weapon to mine the asteroids or something, that's not necessarily covered by that because it's general
sure,
enough not to cover it. It gives the judges and the decision makers, the arbitrators of a free society, it gives them the leeway to look at what's going on and to inform these, to use the context of what's going on to inform how to apply the principle. So I'm pretty happy with the way that one was worded as well.
yeah, I think it came out great. It left plenty of room for responsible use, just as you said, and also addresses the like if these things if handling nukes wasn't in your principles, every legal code would have to figure out a way to handle it. So the drunk next door doesn't have a basement full of nukes, and there's just nothing we can do about it.
Although
You also
as a practical matter, I think that problem would be very rare because um, let's say you have an anarchist community, and you could imagine that a given region would have these everyone's insurance company. Everyone's going to want to be insured
right, right,
to get an insurance uh, uh, coverage. You would have to. The insurance company is going to require many things. It's going to require that number one, you're part of a neighborhood association that itself prevents the use of nukes because
yep,
if you allow nukes next door, then their potential exposure for liability coverage could be too high. So, or you could see someone being ostracized if they're a continual threat. So I think that the problem would be remote anyway, but the principle is there just in case.
amen. I was pleasantly surprised to see you port in under evidentiary standards and procedures. You ported in some wise things that we developed over time,
Correct.
like severe remedies require a heightened evidentiary standard, such as proof beyond a reasonable doubt, unanimous verdicts, double jeopardy protection, jury authority over not just fact but law. You must have been some reason you were specific in porting things in here into the principles layer. Do you have any insight as to
Yeah.
how and or why you did that?
Yeah, well, so number 1, you'll notice somewhere in there, we say that, the judges so this is not a full legal code, and I don't think one can be written. We have to expect different regions to develop their own legal systems, but we say that it's natural to assume that you wouldn't start from nothing because we do have the vast bodies of the Roman law and the common law, which are largely libertarian, so you can expect them to be consulted as sort of a starting point. You can reject the parts that are not libertarian, like blackmail law and women, certain aspects of those laws, but they can be used as starting points. Which is why in that provision you read, I didn't say you have to have a jury trial. I just said um, it was general. I said that it has to be like heightened standards and then and then such as I gave examples. So that's something the judge can consider. It's not a legislation, it's just an example. But I did mention the right of the jury to judge the law and the facts. That was a nod to the jury nullification idea, which is the idea that I mean, if you're gonna have a jury which can whose job is to judge guilt by applying the legal principles, the basic legal principles and those developed by previous legal systems. that are being applied, then they ought to have the right to reject the entire verdict for immorality or for just general principles. So that was what that was in there for.
Amen.
But I didn't say like you have to have 12 jurors, because that's more like legislation, and the particulars. It doesn't have to be unanimous necessarily, and it didn't say which types of cases. Just the more severe cases. The more severe the legal system wants to punish people, which is why I personally believe in a free society, it would probably mostly be a restitution-based system with very little, if no, institutional punishment. Although I think punishment
I
in
agree.
principle can be
Yeah,
justified, I don't think it would be common. It would be more a vigilante thing. But I think it wouldn't be institutional because it's too expensive, it's too risky, it doesn't really achieve anything. And I think it would be largely unnecessary. I think if you have a restitution-based system, that's the best way to handle the response to crime.
I agree completely. It takes something as distortionary as a state to get to the idea that these things should be punitive rather than restorative. I like at the end you have a list of select unjust laws that is not exhaustive, just to give people extra flavor as to what we're talking about here. These principles are good. These specific laws are very, very bad. And I want to
Yeah,
read
we
the.
did. Yeah, well,
Go
let
ahead.
me tell you one reason we did that. We did that because when you have a general statement of principles like this, it has some implications. We wanted to give like some concrete examples of how we think that those principles would apply, because that helps you to interpret the general principles in other cases we didn't mention. Right? It's giving. So like if you could say, well, they clearly say that taxation is not permitted. So that would have implications for other cases we didn't consider. That would be also institutional violations of rights. But go ahead.
Yeah, no, that's great. The closing affirmation is beautiful. It is, quote, the aspiration behind these principles is a world free from systemic aggression, open to every person. Let every free soul remember we bow to no state, we kneel to no order but justice, we answer to no master but reason and ethics. Here, under these principles, we choose life without coercion, without chains, and without tyrants, and no power on earth will stop us. And as I read that, I chuckled and pictured you channeling your inner Ayn Rand as you chose some of those phrases.
And that was more from that final part was more from Max with some input from us. So yeah, that's aspirational. There's nothing wrong with aspirations and putting in there a little bit of what drives us to do this and why people would be motivated to join it.
Yeah, I think that's right too. And as I'm quoting you, I want to quote you again. There's a great paragraph on your blog about this project called, uh, well, here's the quote. The time has come to state our principles clearly, to serve as a basis for any future legal systems. This does not need to be a detailed working legal system for two reasons. First, it is premature. Second, we must recognize that there are limits to armchair and deductive acontextual reasoning. Law has to develop in a certain process, and to be just has to be based on just principles, but developed over time in a decentralized, organic process. The role of libertarian thinkers is to identify, clarify, develop, state, and explain our principles, and to understand existing law and criticize it in light of these principles. And I think that we should say that every morning when we wake up, because most people, when they ask questions about libertarianism and when they pontificate about libertarianism, tend to slip into the habit of just telling you what they think the law should be. And that's
Right.
not how we make law as a civilized species. It's this organic thing that's based on a few principles and applied to every context that it stumbles across. And you can't sit there and say what it should be in every specific case, because that's a process. That's why jurisprudence used to be where the brightest and most creative and brilliant minds would go. It's not like
Yeah.
that anymore. And so I
Yeah.
love that. I wish more people would take that to heart,
And
because it
that's
kind of
how I
goes against
envision
our,
the
yeah,
well,
because it kind
and
of goes
yeah,
against our instincts, right?
I was thinking about, saying, "I swear by my life and love of it," but that might get me in trouble with Atlas Shrugged, Ayn Rand, the copyright, yeah, an affirmation, but, um, yeah, libertarians understandably like to debate, and they always come up with these, armchair hypotheticals. It's almost like the AI problem, or the robot problem of runaway AI turning the world into a paperclip making machine, right?
Right.
If you tell them your goal is to make paperclips, then if that's its only goal, it might turn the entire Earth into a paper clipping factory and kill all life. And by the same token, if you said something general like, um, um, my goal is a world free of aggression. Well, one way to achieve that would be to kill everyone. I mean, to like come up with something that if all life was
No,
ended, there
no
would be no
conflict.
aggression.
Yeah, no
But that's not
conflict.
what we want, right? So when you have these button pushing scenarios like Rothbard and others saying, would you push the button to achieve freedom tomorrow? It's like, well, it depends on what the means is, right? The means matters. Um, So I don't know, which is also the same answer to these hypothetical questions people come up with, like, if someone in the apartment above you falls and they land on the flagpole extending from your apartment on the 10th floor or whatever, they're above you, do you have to let them into your apartment? Or if you don't let them in and they fall to their death, are you responsible for what happened to them? The problem is you can't answer that without a deep contextual background, which is why in the real world, in the Roman law and in the common law develops by the answer given by judges in deciding actual disputes between actual parties when they can take evidence and they can know what the background custom is, they can know what the relevant facts are, they can ask questions. So, for example, you can't just say yes or no to that question about the flagpole because we don't know, is there an agreement between the people? Is there an owner of the building that everyone's renting from where they agree to, like, letting someone use their apartment for emergencies? I mean, we don't know. So the answer is often it depends, which frustrates, dorm room grad students, libertarians who want you
Yeah.
to, from your armchair, answer every question in the end, which is what Rothbard and others do end up doing because they were pioneering a new theory. So they have questions, they pose a possible answer to the question. And then they even say something like, well, someday we'll hammer out the complete legal code of a free society, forgetting that that's not how law has to develop and always has developed and must develop. It must develop organically, incrementally, based upon the situation humans actually are faced with. Um,
Yeah, exactly. Well, it's a magnificent accomplishment. I really hope it takes off and is adopted or at least thought about as we think about how to get towards liberty. I want to dive into one more section before we finish, and I hope I'm not biting off more than our time can chew. Um, there's a whole lot buried in this statement that you say, which is that selling does not imply ownership, and vice versa. Um, it's an important subject because it has to do with this being careful about our legal terms and principles, what we own, what we don't own. It touches on do you own your labor or not, which is um, a very confusing subject. So, yeah, why is the selling and ownership thing not identical? What things do you own that you can't sell, and vice versa?
where did you get that from? Because I don't think that's in the principles.
Oh
I'm
no, it
trying to
isn't.
remember.
I'm changing subjects. It's
Okay,
one of your blog posts that I have
correct.
forgotten which one.
Okay. It's implied by those principles, but again, it's not mentioned, because that's more of an explanation. That is in chapter it's one of the chapters of my book and also in some blog posts. Um, and this gets to another thing you and I've been talking about the concept of dualism, right? And, dualism in Mises, dualism means, methodological dualism, which means it's a way of rejecting monism, which means the one type of science, the one way of understanding human behavior and human social reality, and the dualistic way, which is um, the dualism of Mises is that there are two realms of phenomena that we seek to understand. One is causal, the causal world. And this is what most people think of as science now, which Mises would call the natural sciences, which is just one type of science. And the other science is teleological, that is understanding the implications of human action, right? Which is purpose of human action, um, guided by praxeology or the structure of human action, right? That is, humans employ means to achieve their purposes or their ends. That's human action. The causal world is the world of causal laws, like cause and effect, which we study with the natural with the scientific method, right? And that's what most people now think the word science means only the natural sciences. But of course, it's a broader concept which includes within it the sciences of human action and the causal laws, and they're just different ways of studying those things. And I would say there's other types of sciences. There's moral science and moral ethical knowledge, and then there's a type of dualism there. There's prescriptive versus descriptive. So descriptive means you describe the way things are, or the facts, or the is, and then there's the ought, or values, or norms, right? Rights. So, for example, if there's a law of gravity, it's a causal law that we've discovered, but you don't have to obey it, and you can't not obey it. But if we say there's a law or there's a right not to be aggressed against, that is not self-enforcing like causal laws are. People can violate rights. They can choose this because
Hmm.
these are norms and oughts and prescriptions. They're telling you what you shouldn't do, right? So they're just different types of things that we're talking about. So circling back to remind me, what was your question?
Oh, just
Oh, about selling.
selling and
Okay,
owning. Yeah.
right. So there's something also there. There's an overlap in the way words are used and concepts are used sometimes, and they go back and forth between realms of description without distinguishing, and that can lead to confusion. So, for example, um, people say they own their bitcoins, but what they really mean is they possess their bitcoins, right? So,
Hmm.
the word property is sometimes used to refer to the thing that you own, and it's also sometimes used to your control or your possession of that thing, which is a descriptive matter. Um, eh, Likewise, the concept of selling or exchange is both an economic or descriptive concept, and it's also a legal concept, right? So, for example, Robinson Crusoe, alone on his island, it only has the realm of causality to guide him, right? Praxeology applies because he's acting to achieve ends, but he doesn't have any ownership of the things he possesses. That's purely
I want to.
possession. Yeah,
I
go ahead.
want you to hit that several times.
Okay.
There
So
is no
Mises,
ownership because there is no other person. There is no other community for us to have a claim of I own this and you do not own this.
right, and
That's
the
why
and the
there is no
average
ownership there. Yeah.
yeah, the average person would say, "Well, that's not true. He owns the resources he's using." But that's because they're using the word ownership to mean possession. Now, Mises recognized this early on in socialism and in human action, and he distinguished between in socialism. He calls it um, he says there's two types of ownership. Now, I think he misuses he shouldn't use the word ownership. He should use possession, but he still makes a distinction. He calls it
Hmm.
sociological ownership and juristic ownership or legal ownership. And then in human action, he says there's catalactic ownership and juristic ownership. So what he's distinguishing between is possession of a means, which is what any human actor does. Even Crusoe alone on his island, he has to have the ability to control causally efficacious scarce means of action as part of his action. That's control or possession, which is what Mises means by catalactic ownership. Okay, that's fine. Um, in society, when there's other people around, now you have a threat to your ability to use these resources. You have a threat that others might want to use that resource, which is why there's a potential for conflict because resources can only be used by one person at a time. And if you don't have a norm evolved, that is the right to use this, then people can just take it unless you lock everything down and you're always guarding it or something like that, which is inefficient. So people develop a norm. They're saying, because I'm the one to first use this resource, or because I control my body, I not only have the ability to use that resource and that means, but I have the right to use it, which means you should respect that. That's the prescriptive part, right? So it's only when other people enter the picture that there's a threat to your possession or control of a resource, and that's why these property norms and these rights arise in society, right? So that's the difference. So when we talk about exchange or selling something, the word sell has two meanings. It it means giving something away where you no longer possess it. That's a purely descriptive or economic category. But it also means that now in the legal system that respects property rights, that there's a change of ownership as well. So those are usually related and they're usually go together, but they're different concepts. And but because we use the same word for both, like selling, then it leads to confusion, which is why people like Walter Block and others think that you have the right to sell yourself into slavery because th- they're recognizing that possession of something leads to ownership in both ownership of your body and in scarce resources which you acquire. And so they're saying, well, if you have the right to sell an apple that you homesteaded, then you also have the right to sell your body because you own that too. So they're going they're going from they're assuming that the capacity to sell or the right to sell is an incident of ownership, but it's not. Ownership is really the right to exclude people from using your resource, right? It doesn't automatically imply the right to sell it because if you have a right to something, then people just don't have the right. They don't have it's immoral for them to invade your use of it without your consent. Nothing about that statement says that you have the right to get rid of that right, right?
Mm.
Now you do, but only in certain circumstances, only if you abandon it or if you committed an act of aggression. That's the cases where people can use your resource without your permission. Now, the reason why, in my view, and I elaborate on this in my book in chapter 9 on my contract theory, um, the reason you have the right to sell a thing in the legal sense, that is to get rid of your ownership of it, which is a legal concept, a juristic concept, is because you acquired it and it was unowned. And
Mhm.
because you acquired it and you didn't have to acquire it and you only maintain ownership of it so long as you still intend to own it, then you can abandon that that's why you can sell it. So you can sell things because you can abandon them. You can abandon them because of the way you acquired them, right? And this requires to understand this, it requires you to distinguish between possession and ownership. So for example, if I lend you my car for a day, you are not the owner. I'm still the owner. I'm just giving you the right to use. I'm consenting to your use of the car, but you're not the owner of that car. So in those cases, most average people understand the distinction between possession and ownership. There's the possession of the car by the guy I lent it to, and there's the ownership which I retain. That shows the importance of keeping the word ownership restricted to legal ownership, but not to possession, right? And so when I sell something, when we analyze it economically with the pure laws of economics, we're analyzing just the descriptive or the economic aspects of it. So we say two people engage in exchange. Why do they do that? When we say that, we're trying to analyze the motivations of their action, the structure of their action. So I'm saying the reason I gave you the apple is to obtain possession of your orange, and the reason you gave me your orange is to obtain possession of my apple. That's the explanation of the motivations of two independent but related actions of exchange. But in a legal system that recognizes the ownership that flows from that, it's also a legal exchange, right? So there's a parallel in most exchanges of tangible, owned corporeal objects. There's a parallel between the economic description of that exchange and the legal exchange. But when you sell something like a service,
Labor,
right?
yeah.
Like labor, when you have an employment contract, for example, um, those cases can be explained by economics as well. So again, you explain what's the reason that I engaged in this action of handing you my apple or my money. It was to induce you to perform an action I wanted you to perform. See, this gets to the point that the general structure of human action is to achieve an end in the future. It's not to obtain ownership of a thing. Sometimes it is, but that's only a subset of all actions. It's probably a very minor subset of all actions. So the vast majority of things that you engage in are to achieve an end in the future. Sometimes it involves other people, sometimes it doesn't. Um, and sometimes it involves the acquisition of an object that you want to own, and sometimes it doesn't, right? But they can all be explained by economic reasoning. Like you're explaining the structure of that action, the means the guy employed to achieve his end, and the end he was aiming at achieving, right? So if two people with an apple and an orange, and they each want the other's possessed and owned object, then they engage in economic exchange and legal exchange of the titles. But if I want you to perform an action for me, like a service, then the guy performing the service wants my property. He wants my owned money, like he wants payment. But I only want him to perform an action. So that is again an economic exchange, but legally it's only a one-way exchange, right? So the only thing that's being transferred legally is the title to the money because that's the only thing that's owned. And you can understand this better if you understand that you have the right to make a gift, right? So I can give you my car for no reason whatsoever. I can just gift it to you. Like, the end of my action is whatever reason motivates me to give you my car. Maybe it's to make you happy. Maybe it's because I wanna see what you do with it. I don't know, whatever. Maybe I'm tired of having the car. That's just the end of my action. That explains why I did it. And then legally, the legal system recognizes that transfer, right? So, when when it comes to selling one's body, uh, that's just a metaphorical way of describing what an employment contract is. So, we're describing an employer wants you to perform an action or a service for him, and the reason you do it is to get money from me, from the employer. But what I wanted you to do is perform a service. But it's not like I own the service after you perform it. It's not like there's some labor that you're transferring to me, right? It's just that you did what I wanted done because that's the end of my action. So that's why it's a little bit misleading to describe an employment contract as a sale. It is a sale in the economic sense because that describes why each person did what they did, but in the legal sense, it's only a one-way sale. It's a sale of my gold, and you're performing an action, the service that I want you to perform.
Does that imply that there's something missing in the legal analysis?
Yes, I
Because
think the legal analysis is corrupted because the legal system went astray a long time ago by thinking of contracts as as enforceable binding promises, which is what
yeah,
Rothbard and Evers' revolutionary contract theory corrects for by saying, no, you got it all wrong. Contracts should not be seen as binding obligations enforceable by the legal system that arise from the making of promises, but rather it should just be seen as conditional transfers of title to things that can be owned. So in a contract for a service or an employment, the way to look at it legally is that the owner of a resource, that is money, is conditionally transferring ownership of his owned resource, that's the money, conditioned upon the performance of a service by the other guy. But it doesn't imply that he owns his labor or he owns his actions or he owns his service. It implies that he has the ability to choose not to do it because he has control and ownership of his body. So he can choose not to engage in the action that you want him to engage in. He can withhold it. He can say, "I'm only going to paint your fence if you agree to pay, if you transfer money to me." Right? So I make a conditional transfer of money to the guy conditioned upon or triggered by his performing of a specified action.
you can certainly see why the fence painter would say to somebody, I sold this guy a fence painting for $50, or a haircut. I sold him a haircut. Is there anything
Correct.
is there
Correct.
anything
And
wrong with people using or thinking about these things this way? I get your legal distinction, but there is an
yeah,
exchange.
it's wrong because so economically they're correct. So in the economic sense, they're correct. It's a way to describe the exchange of the transaction. Why did I conditionally transfer my money? I did it to obtain some end, and the end was to motivate someone to perform a service. Why did the guy perform the service? He did it because he knew that it would trigger the transfer of title of money to him. That's economically and descriptively explains why they did it.
But
So
legally,
that's what
all we can
people.
talk about is property transfer,
But
right?
legally, but then the problem with calling it a sale is it leads to the presumption that what you're selling is, so they're saying that, well, some sales are exchanges of owned things. So in the prototypical example of an exchange, there's an economic exchange of one object for another that's controlled and owned, and that leads to a legal exchange of title as well. But then when you analogize it to a one-way sale, like a service or a labor sale, people say, well, economically, we describe it as a sale, so there must be something that was sold legally. And that's the mistake they're making. So they're assuming that the laborer owns his labor. So once you make that assumption and that mistaken assumption, then it leads to intellectual property, right? Because people start saying, well, the reason I was able to get the money for performing my service is I sold my labor, which means I must own my labor. The only reason I sold it was I owned it. And if I own my labor, I own other things that I create with my labor. And then you get the intellectual property mistake. So that is the problem of making that sloppy equivocation between the two types of sale. So which is why it either gets tedious to keep reminding people you're using the word property in two senses or using the word sale in two senses. But unfortunately, because we're talking about two realms of behavior, two realms of analysis, right? We're talking the descriptive causal world on the one hand, and the teleological world, and then the normative ethical world on the other of laws and rights and ownership.
So, in the battle between dualism and monism, who's winning? Who's ahead?
I think that monism has won the day because we live in a world of scientism, and we live in a world where because the physics and the causal sciences and engineering have been so successful, and because Milton Friedman and the positivist in the 20th century made people think of the word science as the causal sciences only, which is why economics, other than the Austrians in the 20th century, started adopting or aping the methods of the sciences to appear scientific. So they started doing econometrics and experiments, and they have hypotheses. So the the model, and so and then that led to people dismissing everything else as pseudoscience, right? So philosophy and moral theory and ethics and rights all got dismissed as just opinions or just subjective value preferences, and it's
Or
unscientific.
or hallucinations in the case of like free will or something.
And that gets to another thing. So the free will issue is one I think can also I won't say it can be solved that easily, but I have my own view about the right way to look at that issue, which I think the only way to unlock it is to have a clear, kind of a dualistic understanding of the difference between the phenomena that you're analyzing. So um, the way I look at the free will debate for me, everyone that I read on that issue frustrates me. Um, because it's not like the atheist debate. Almost all the atheists, I think, are wrong in their reasons for opposing God. Um, they're right that there's no evidence for it. Okay, but the reason they say that is because they think that the model of science is you propose a hypothesis and you reject it if you can't prove it with a controlled experiment, something like that, right? If you can't have a falsifiable answer. So most of the new atheists, right, the Dawkins types and the Sam Harris and the Hitchens and all these guys, they'll say, "Oh, it's extremely unlikely that there's a God," because they're viewing things empirically only. So they're leaving open the possibility. Well, maybe, but someone could prove it. It's just very unlikely because they don't have a philosophical way of looking at this problem, and realizing that in my view the concept of God is completely incoherent and can be rejected out of hand. But that's another issue. On the free will issue, they have like Sam Harris who rejects free will, but his reasoning is, well, there's been these neuroscientific experiments that show that your brain got a signal like 2 microseconds before you acted, so that proves that. But they're just trying. They're pushing the problem back just by a level. They're
Seems
not
pretty
really.
desperate. Yeah.
Yeah. What they don't understand, I think, um, is that we have 2 ways of analyzing phenomena in the world, and one is the causal realm, and in that realm, humans behave. And then there's the human action, the teleological realm of human action where people have purposes. Now, from the inside of our bodies, from the inside of our minds, we perceive of ourselves as having goals and values, and we can see our own choices that we make. We have ends that we pursue. Now, and therefore, when we see other people that we understand biologically are similar to us, so we have no reason to think that they have a different internal experience, it becomes useful for us to model what they're doing as action. It's also true that every person is a collection of quarks and atoms which follow the 4 laws of physics as far as we know. Um, so in principle, you could, like Mises says, in principle, God can understand things omnisciently, right? In principle, you could explain what someone is doing by analyzing their behavior as a huge cloud of quarks with just physics equations. But that is just not useful to us humans with limited cognitive capacity, and we find it most efficient to understand and view other people as actors rather than behaviors, right? So we view other people as actors for conceptual economy, right? Because that's the most useful way we have to engage with them. We think of them, well, they're probably having the same subjective structure of action as we do. They have means that they're and they choose like we choose. Like we have an end in mind and we go for that end by choosing means to achieve it, things like that. That's just the best and most efficient way to understand other people's actions rather than as behaviors. So in that sense, it's unavoidable, at least in today's world, and I think always will be, it's unavoidable to conceive of other people, to characterize them as actors in a teleological sense. And in that sense, you can't help but try to attribute purpose to them, which means why did he do that or what is he going to do if I'm an entrepreneur trying to predict what people will do in the future? I'm trying to imagine what goals they might choose or what goal a guy did choose. Like, why did the guy rob the store? Why did the guy build the car? Well, to achieve certain ends, right? That explains what he's doing, helps me to understand it, helps me to be successful in the world dealing with other human beings, right? In the causal realm, I think it's unavoidably true that there can be no free will in the causal sense, because free will implies that the collection of atoms that constitute your body somehow go down and exert causality on the structure itself, right? Which is what's called downward causation. And some more honest advocates of free will, like David Kelly and the objectivists, they frankly admit this, which I think is the only way to have causal free will is to have downward causation. But to me, that's just logical nonsense. You can't have something exert cause on the thing that makes up that thing, right? Um, but in the teleological sense, I think it makes sense to say, yeah, I'm describing what he did was he chose that means because that was his goal, right? So that's my type of Misesian compatibilism, I call it, because compatibilism of the scientific types, like I think Richard Dawkins is, he says, well, there's a compatibility between free will and choice because it just doesn't make a lot of sense. He's trying to square the circle by staying within the scientific realm only, the realm of monism. That's sort of my rough. That's the way I think the only way we can solve that problem. I don't think I've solved it, but no one has written on it that satisfies me. So that's sort of the Kinsella view I'm stuck with in the corners of my
I got
mind.
you. I don't have a solution. I think the one you just described is maybe compatible, but maybe also a little schizophrenic. I I
Yes.
I I'm happy accepting the fact that I have free will just because it seems self-evident. I'm very sympathetic to the quarks and atoms determinism, but
Right.
there's so many things we don't know about physics that I'm going to have to be satisfied with the fact that I can't square the circle and I don't really know what's going on here. So I just put it as we need to investigate more and learn more. I don't know.
I agree with that, but that means in the causal realm, but in a sense, you're right that it doesn't matter because from our perspective as valuing human agents
Yeah.
who do have a mind and we do have our own values and purposes. I know that I have values because that's what I act to achieve. And so it doesn't matter if you can prove or not prove in the causal realm whether there's really downward causation or some spooky quantum connection or some
Right.
randomness that gives some kind of room for free will. It doesn't matter because in the teleological realm, I do have choice because I choose things, and
For sure.
the useful description of what I'm doing. In the physics realm, I think it's possible that there's randomness, but I don't think that still gives in the causal way. I don't think that gives room for free will. It just means our actions are random. Um, and even if you found a fifth physical force, that just means there's a fifth force that we don't know about. But it would still be causal. But
I have heard
I don't
right.
claim to, I haven't written on this a lot because I don't claim to be an expert on this. That's my sort of my pet
Yeah.
theory.
I wouldn't dare write on it. I have heard people try and use the mysteries of quantum mechanics to explain how the one, impacts the other in some weird way that, since I don't understand quantum mechanics, I can't evaluate. But it seems like my perspective is the right way to think about it, and everyone else is just trying to claim certainty that they don't have. But what do I know? These people are smarter than me, so.
They are
Anyway,
smart, but sometimes sometimes they're not smart enough to know what they don't know, and because they're the smartest guy in the room,
yeah,
they think they can pronounce on other things too. They just like lawyers. Lawyers are good at the
yeah,
law, so they think they can tell you what the law should be. It's like someone says, "Oh, you're the only patent lawyer who doesn't believe in patent law. Every other patent lawyer believes in patent law." It's like, well, they understand patent law. It doesn't mean that they have an argument for the right property rights theory.
I believe in the statutes as written. What does belief even mean?
Correct. Correct.
Well, I want to be mindful of both your time and the audience. Is there anything else you want to say on this beautiful document, the Universal Principles of Liberty, or anything else?
Well, I welcome any comments on it, of course. And when I go to the Liberland meeting in Prague next month, they're going to finalize their constitution. And one thing I'm going to do there is there's going to be a 3-hour session with the delegates, of which I think I might be one. And they're going to try to tweak it and improve it. And what I'm going to try to do is persuade them to add a provision saying that the universal principles of liberty, which I wrote, um, should be incorporated to the extent that they're compatible with that. So even if it's got a statist aspect to it, at least the principle of liberty can be there to nudge it in a more libertarian way in cases where it's silent or things like that may come up. Now, you asked earlier why I did this. The reason I did it was because, as I said, I was trying to have an excuse to sit down finally and codify our principles. And I just was dragging my heels for a decade because I didn't want to write a constitution, or I didn't want to write a details. Like I've thought about taking the Louisiana Civil Code and rewriting the whole thing from scratch and fixing the bad parts and adding other parts. But that's so premature and it's so pointless.
Right.
Um, uh, and I don't I think that to will the attempt to make that into a free society is also a long shot because we live in a statist world. So uh, I did that project. I used that project as an excuse to motivate me to write it. So I'm happy that it was written. I'm really happy with how it turned out, and I want to see what can be built upon that.
Amen. In the show notes, which you will be able to find at my Substack, hamannature.com, or the YouTube channel, also Haman Nature. We'll put links to all these things we're talking about. But for folks who are just listening, where would you like to direct them so that they may bask in the fount of your wisdom?
Well, I do podcasts here on occasion, and my website, stephankinsella.com, has all my writing. For the next couple years, I expect my main project to be writing a brand new book from scratch on copyright on intellectual property. I'm going to call it Copy This Book. So that's my next project. And when I finish that, it will supersede everything I've written before, because I have about 20 or 30 or 50 articles on IP at this point. I need to put them all together into one comprehensive treatment. So that's my next big project.
Exciting. All right, sir. Always great to talk to you. Thank you so much. And ladies and gentlemen, thank you for listening and watching. We'll catch you next time on Haman Nature.